Today, we want to introduce you to the beneficiary designations. Obviously, the definition of beneficiary will be the individual who is actually going to receive the monies once you pass away. So that's the simplest definition, is who's going to get my money once I pass away. So I'm insured for $500,000. Who do I leave this $500,000 upon my death? Okay. And so the designation is very, very important. How we designate individuals is very important. And of course, it could be a person or a person. So it could be your spouse, it could be whoever. So it could be a number of persons, because it doesn't have to be restricted to one individual. So it could be a person or persons. It could also be a class of person or persons, okay, basically. In other words, for example, a very, very common one is all my children. So if I don't have necessarily a spouse, I could turn around and say, okay, in the event that I pass away, my $500,000 will be split between, let's say, my 4 children in equal proportion, things of that, or my grandchildren, whatever. So that would be basically a class of persons. Okay. I can also leave my business. So, for example, a key person insurance policy, the insurance company will, your company will own a policy on your life, and they become the beneficiary of that as well. So, key person insurance, for example, partnership insurance, corporate-owned insurance, all those things there. Okay, they become the owner, but they also become the actual beneficiary as well. So, certainly, any business could also be the beneficiary. Okay? It could also be a trust. Some of your clients who are in the upper end market, let's say, more affluent, high net worth clients and everything, you'll find that a lot of them have trust, whereby they leave monies in trust for whatever purpose that may be. It could be for a dependent, it could be for the children, it could be for a spouse, it could be a whole host of different things, okay? So basically, if you don't want to leave the money directly to your children, for example, you may leave it in a trust, and that trust then will speak for you when you can't. So for example, can minor children be named beneficiary? The answer is yes. Of course, you can name anybody you want as a beneficiary. So can minor children be beneficiaries? The answer is yes. However, can they receive the money given the fact that they're minor children? The answer is no. Okay, that's the issue. So if you have a 12-year-old and a 14-year-old, let's say, and it's $500,000 and you name them as beneficiaries, they're not going to get the $500,000. What will end up happening is it's going to be paid out to the courts, which is in turn gives the money to what's called the public trustees, and the public trustees then will manage the money until the children are of age and majority, and then distribute the money at let's say at age 18, for example, in Ontario. Now, the problem with that, of course, is that at age 18, this child receives a whole pile of money. They may blow it. So that may not necessarily be the best thing for you to do, is to turn around and leave money to the children, through an insurance policy, so that at age 18 they get a big lump sum of money, and then they'll end up squandering the money. So if you're concerned about that, what you would do is set up based in an insurance trust. Okay, and so the trust is set up. Trust is the beneficiary. $500,000, I die. $500,000 goes into the trust. The trust now manages things according to the way you would have done it, because you would have named a trustee, somebody that's going to manage these funds for you. Usually somebody that you know, or somebody that knows the family and all this, named as the executor or the trustee of the funds, and the money will be managed accordingly. And then to say in the trust, you may say, well, when the child reaches 18 and they do go to university, for example, pay out money for university costs and all that. If the kid doesn't go to a university, do not pay out anything at all, until they're 25, until they're 30. In other words, the trust allows you to basically control the insurance proceeds beyond the grave. In other words, you passed away. What would you have done with this $500,000 had you, in fact, still been alive? Okay, would you have actually handed out $500,000 to your son at age 18? More than likely, no. Why would you do that? Okay, you would manage the money accordingly and everything. So a trust allows you to basically manage the money beyond the grave, because the executor or the trustees basically of the trust have been given instructions by you to say, here's how I want the money to be distributed. If he goes to university, pay this. If he doesn't, then don't pay it. At age 25, yes, pay some money out. Age 30, and so on and so forth, okay? So you can basically decide how you want that money actually distributed. Whereas if you left it directly to them, then, like I said, you've got the public trustee issues, and all they're going to do is manage it until they're age 18, and then at age 18, the money gets released, and the money could be squandered and everything. And the last one, of course, is the estate. Everybody in this room has an estate. Anything that you own is part of your estate. So therefore, if you leave money to the estate, money will be paid to your estate. The problem with leaving money to your estate is a number of things, and I don't want to belabor this, but keeping it simple, basically, is that the estate is subject to taxation. So all of a sudden, this $500,000 could be subject to some form of taxation, probate fees, all kinds of different things. But the more serious one is that your estate is subject to creditor attack. So if you wanted to leave $500,000 to your spouse or to a child or whatever it is, by leaving it through the estate, you might find that they don't get all of it, because there will be estate taxes that have to be paid. There may be creditors who may chase after the money as well because you left money behind. There may be taxation issues. The CRA assesses your tax form and then discovers that in actual fact you owe money to them, so they may take some of that $500,000 to pay off those taxes and everything. So we usually don't recommend that you use the estate as a beneficiary. However, it is the default basically beneficiary in the event you don't name anybody. The insurance company will automatically just simply pay it to the estate, because like I said, once a person dies, we all have an estate of some sort. How we deal with that estate, of course, will be up to us and everything else, But these are essentially what happens as far as beneficiary designations are concerned. Okay? Now, when you're naming a person or class of persons or as an estate, as a beneficiary, okay, there are two things you have to keep in mind. If you name them as a revocable beneficiary, so let's say you name your spouse as a revocable beneficiary, because it's a revocable beneficiary, you're not tied up in any way, shape, or form as to what you can do with your contract. So if you decide to change the beneficiary, you can go ahead and do it. You don't have to notify the current beneficiary and say, look, I want to change it to so-and-so, whatever it is. They don't even have to know any of this, because as a revocable beneficiary, they don't have any rights in the contract. All the rights lie with you. Okay, so you as the insured basically have all the rights. You've not transferred any rights onto the revocable beneficiary. So if you decide that you want to cancel a contract, that's your privilege. Okay, you want to increase the coverage, you want to decrease the coverage, you want to borrow money against it, you want to sign the policy. In other words, all the rights under contractual rights in that contract lie with you. So you do not have to notify the revocable beneficiary that you're going to be doing any of this stuff at all. Okay, and so revocable beneficiary gives you all the power basically. On the other hand, if you name somebody an irrevocable beneficiary, now you have handed over a lot of power over to that irrevocable beneficiary. So as a result, now, if you wanted to change beneficiaries, for example, you have to notify the irrevocable beneficiary. They have to give you permission to be able to do that, okay? If you want to cancel the contract, you have to get permission from the irrevocable beneficiary. If you want to borrow against the policy, if you want to absolutely assign the contract, collaterally assign the contract. In other words, all your contractual obligations that you basically had under the contract are now transferred over to the irrevocable beneficiary as well. So you can't just go ahead and arbitrarily do anything you like without the beneficiary actually knowing about and giving you approval to that. So the revocable beneficiary gives you all the flexibility you want. Irrevocable beneficiary, on the end, really ties your hands. So you have to think very carefully before you name somebody as irrevocable beneficiary, because you will in fact lose control of that policy. So the obvious question is, why would anybody appoint something on an irrevocable basis? Okay. Well, sometimes it may be a legal issue. It may be a legal issue. So, for example, if you have a marital breakdown and you're giving child or spousal support, let's say, to your spouse for, let's say, $50,000 a year, whatever it is, the court may order you to buy a life insurance policy, because obviously, if you died and you don't have anything, that $50,000 is gone. it's just finished. Okay, as simple as that. So the courts themselves, part of your marital settlement, the divorce settlement, basically, is that they may say you have to go and buy, let's say, $1 million life insurance policy and name the beneficiary as irrevocable. So that way the spouse has control over this policy, so they will know that you're paying the premium. They will know that things are working out, just in case you pass away or something. That way they continue on getting that child support. They continue on getting the spouse support, again, beyond the grave. So it may very well be that it is a legal matter, a contractual matter, basically, as part of the divorce settlement that you need to be insured. And so, therefore, to give that spouse power, you might say, the courts will order you to name the beneficiary as irrevocable. The other one, of course, is creditors. For the most part, life insurance policies are creditor-proof, okay? But it's creditor-proof provided they go to what we call the preferred class. And the preferred class is basically, you might say, your parents, your spouse, your kids, your grandkids. In other words, what I call the trunk of the tree, basically. In other words, those are preferred. So that's not a problem. People cannot. So if you leave money to your spouse, if you leave money to your kids, if you leave money to your parents, whatever it is, creditors cannot go after that money. Even though you may owe money, they cannot go after that money because it is a preferred class. But if you leave money to a sibling, your brother, your sister, your niece, whatever, something like that, they are not considered part of the preferred class. So if you owe money to creditors and you left the $500,000, say, to your brother, they could in fact sue the brother for a portion of that $500,000 and everything. So how to get around that situation is to name your brother, once again, irrevocable. So by naming irrevocable, you also shut the door to the creditors chasing after that money. So those are the two biggest ones. There's a few other ones, but those are your two biggest ones that why you would name somebody as irrevocable. It's a legal matter, or it could be a creditor situation. The other thing you have to remember is that if you die, okay, obviously the money will go to your beneficiary and everything, all that sort of thing. But what happens in the case of a marriage situation where the marriage breaks down? A marriage breakdown does not, and I repeat, does not change the beneficiary designation. Okay, so if you have your spouse as a revocable or irrevocable beneficiary, whatever it is, and then the marriage breaks down, you may say to yourself, well, the marriage broke down, so therefore that means that the insurance policy has changed. It does not change. In other words, a divorce does not negate the marital, the beneficiary designation. You have to let the company know. You have to let the insurance company know you're changing the definition of the beneficiary, whatever it is, okay? So a divorce does not negate the beneficiary designation, something you need to physically do. So you need to notify the insurance company that now you're remarried or you're divorced or whatever the case will be, and the new beneficiary will be so-and-so and so-and-so, whatever it is. Otherwise, upon your death, you can see whether there's going to be some issues to be resolved. Okay? The other thing to remember is in the absence of a beneficiary, what happens in the event that the beneficiary predeceases you, and that can happen, okay? So if you and I were on a plane, let's say, and we're on our way to Europe, and you're the beneficiary as my $500,000 policy, but the plane goes down and we both die, okay, we both perish. The insurance company is going to say, well, who's the beneficiary? Well, it's so-and-so, my spouse, whatever. However, the spouse is also dead. So in other words, we don't have a beneficiary anymore. There is no beneficiary. So what is the insurance company going to do? Where are they going to pay this money? They're going to pay the amount of money to the estate. And that's an important part, okay? And the question really is, to whose estate are we going to be paid? The money will be paid to the estate of the insured. In other words, the money will be paid to my estate. So I go back to the example, you're my beneficiary, I have a $500,000 life insurance policy, you're my beneficiary, you died, I died, there's no beneficiary left, so therefore they cannot designate a beneficiary. Where does the $500,000 going to get paid? It's going to get paid to my estate. So it goes back to here. But then again, like I said earlier, it may be subject to creditors, it could be subject to taxation, and so on, right? So what we recommend is instead of having that kind of situation, is have a contingent beneficiary. In other words, have a secondary beneficiary. So I can have you as my spouse, let's say, as the beneficiary, and in the event that you predecease me, all my children, let's say equal proportion, whatever, all 4 children or whatever the case may be. So we always recommend that you have a contingent beneficiary just in case the primary beneficiary passes away. Therefore, it avoids the money going into the estate, so therefore it will then go to the second layer, the contingent beneficiary. So once again, it bypasses the estate, bypasses probate, bypasses creditors, bypasses all that sort of stuff there, and so that money goes directly from me right to that secondary beneficiary. So make sure that you name somebody as a contingent beneficiary. It's a very, very important part of the succession planning and everything else. So we'll leave it at that, and we will see you shortly.